All right, what are we doing?
Your Honor, we just need to plead impossibility at this point and then waive it over to the circuit court.
This opening exchange looks simple, but it signals a major procedural move that changes the entire direction of the case. What the defense is doing here is essentially bypassing the preliminary examination and pushing the case straight into circuit court. That's not a casual decision, it's strategic. A preliminary exam is where the prosecution must prove probable cause. It's the first opportunity to challenge the strength of their case, question witnesses, and expose weaknesses. By waiving that, the defense is giving up an early fight. That could mean one of two things. Either they believe the prosecution already has enough to pass that stage easily, or they're choosing to save their arguments for a higher court where stakes and leverage are greater. Notice how calm and direct the exchange is. No hesitation, no confusion. That usually indicates this was pre-discussed between attorney and client. But here's the real question. Is this confidence in a bigger strategy or an attempt to avoid something damaging that might come out during that hearing? Because once this moves to circuit court, everything escalates. Penalties, scrutiny, and consequences. This isn't just a procedural shortcut, it's a calculated risk.
Not sure why you would have to do that, but so he's just doing a waiver.
Yes, Your Honor, there's a waiver in the file.
So you're waiving your right to have a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed.
Yes, sir.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir.
All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant bound over to circuit court on a single count. As to the arraignment,
Waive former reading, stand mute, Your Honor.
defendant having waived former reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
March 11th at 1:30 before Judge Conlon.
March 11th, 2026, 1:30 before Judge Conlon.
Thank you, Your Honor.
Thank you.
Your Honor, before we close
Yes.
the record, I also spoke with defense counsel about having his client agree to move the bond payment over to child support arrears.
Now the conversation pivots from criminal procedure to financial accountability, and this is where things get layered. The court is addressing bond money being redirected to child support obligations. This is not unusual. Courts have the authority to apply funds like bond payments toward outstanding child support, especially when there's an active arrearage. But here's where it gets complicated. The defense just learned the bond was posted recently. The court references prior orders. Dates are being compared. This is real courtroom friction. Information doesn't always arrive neatly, and decisions have to adjust in real time. And notice the defense's concern. They want to ensure the money goes to the correct child support case. That matters because multiple cases can exist across jurisdictions. If funds are misapplied, odds of correcting it later becomes difficult and time-consuming. This moment highlights something most people overlook. Legal cases are not just about guilt or innocence. They're also about financial responsibility, enforcement, and administrative precision. And sometimes those financial consequences can outlast the criminal case itself.
That we went through this, and typically that is done at arraignment automatically. But let's see if this slipped through.
Your Honor, I just learned he posted bond last night, but we don't oppose the being applied to the
He
arrearage.
just posted bond last night. Yeah,
I just
right,
found
but
out.
the bond. Right, but the order that if he did should have been done at arraignment. Yes, and it on December 19th, 2025, there's an order from his arraignment that bond to be released to, and then it states the case number.
This happened January 2nd already to circuit court.
It already went over.
That did, yes.
So it's already gone over.
Correct.
All right. So we checked, and that was the date of the order was in December, and then January 2nd, I'm informed, or something like that, it went over to circuit court from 15th District Court. Okay?
And I do believe the concern is my client has several child support cases. We want to make sure that that bond is applied to this child's case. There's only one current case active.
Only one what?
One current arrearage case that I was able to find in the system
For Washington.
for Washtenaw County. I don't know of any other counties currently.
So I can just tell you, now that I can find it again. The bond form clearly indicates that it is going to be paid over on case 2013-298 DP.
If there's any problems, I'll reach out to the DA's office and we'll rectify the situation.
Sure.
Your Honor.
It's being paid over to the case that's in the complaint. So,
Perfect. Thank you, Your Honor.
Thank you.
thank you. All right, thank you, folks. What?
Anything else?
What do you mean we lost Elman? Okay, where are all the people? Well, not you guys. I see you. Where are all the attorneys?
This is where the courtroom dynamic shifts from formal procedure to visible frustration. The judge is no longer just managing cases. He's managing people, timing, and control. And right now, that control is slipping. Attorneys are missing. Cases are delayed. And every minute wasted in a courtroom has a ripple effect. Other cases get pushed back, witnesses wait longer, and the judge's schedule tightens. But watch how this plays out. The judge uses humor, mentions of free kittens, we you're never sake, and the room laughs. That's not accidental, it's a pressure release. Judges often use humor strategically to ease tension while still sending a message. This situation is not acceptable, because underneath the jokes there's a clear signal. Courtroom order matters. When professionals aren't present or prepared, it disrupts the integrity of the process. And here's the deeper question. Does this kind of disorganization affect outcomes? Or is it simply part of a system that has to constantly adapt in real time?
Happy to go out on my way out and see where they're at. Right.
Yeah, when you go out and tell them I'm like really angry.
I'll tell them that you're giving out free kittens. They'll get them all the time.
Okay, that's a little weird. I say just tell them I'm angry. Free kittens. Hey, thinking of all the stuff I've done in my life, I've never given away free kittens. I don't know what he said. Well,
We were here a long time, but I'm in that room.
what do you mean we were here a long time?
Oh, she knows. They're there.
No, they said they've never seen you before. No. All right, but
I don't know where the prosecutor is with,
I have no idea. I've seen one prosecutor, and that's the Attorney General. I've not seen any Washtenaw County prosecutor.
he was in here, Mr. Yeah, we were here early.
Oh, well, lo and behold,
It wasn't him, but the other one.
as we speak.
He's not my prosecutor.
Yeah.
I'm in the conference room though.
What?
So, I'm in the conference room with a client.
Okay, so you're not ready on your case?
Well, we're ready. He said he had to look to see if his people were here, the prosecutor, not this prosecutor. He had to look to see if his people were here, but we could come in.
Ms. Farnwell, who are you?
The blonde guy.
The blind guy.
Sorry.
Who is it?
Mr. Cook.
Oh, Mr. Cook.
He's talking to someone in the conference room. I'll go grab what case?
Oh, no, I'll wait. You guys figure out what you need to do. Mr. Childers, you have anything ready?
I have, Mr. Kawan White is ready with Mr. Denowith. I don't see Mr. Denowith.
Yeah.
If you have Mr. Elman.
I think I'm currently the only attorney in the courtroom, so.
I'm sorry?
If you have Mr. Elman.
Mr. Elman, yeah, we're ready.
Ready on here.
I'm Perry, yes. I can probably get Mr. Elman.
Okay. He walked in and then. I need to start screaming and yelling. Then they'll all run in. Everybody will come in then. I gotta quit being kind and gentle. Mr. Elman's here. Thank you guys for coming in. I'm gonna take a recess. No, I'm kidding.
Terribly sorry, Your Honor.
You're ready on Perry?
Yes, Your Honor.
Court does call the case of People versus Jimmy Lee Perry.
Good morning on this beautiful morning, Your Honor. Robert Ellman on behalf of Mr. Perry. Your Honors, you may recall last time we were set for exam, Mr. Perry had been transported into treatment over at Sacred Heart.
Now we transition into a different type of legal situation, one involving treatment, custody status, and timing. The defense explains that the defendant is currently in treatment and not physically present in court. That immediately raises a procedural issue. Can the case proceed without him? The defense requests an adjournment, which is essentially a delay, and this is where courtroom balance comes into play. On one side, the defendant is in treatment, something courts generally support, especially if it's part of rehabilitation. On the other side, the prosecution has witnesses ready. Their time matters too. Notice how the prosecution responds. They don't outright oppose, but they highlight that their witnesses are present. That's strategic. It signals readiness while leaving room for the judge's discretion. And then the judge steps in, slightly irritated but controlled, and sets a new date. That's the role of the court, to balance fairness with efficiency. This moment may not seem dramatic, but it reveals how justice actually works. Not in big explosive moments, but in constant negotiation, timing decisions, and strategic positioning by both sides.
Yes.
I did call them Friday, and he was still in treatment. His tentative completion date was today. I've checked with jail staff this morning. He's not on the list of people here in custody, so I believe, based on those two things, that he's still in treatment at this time or in the process of completing and being transported back.
You're asking for an adjournment?
Yes, Your Honor.
Not a bench warrant.
I need a little more coffee this morning. Apologies.
And there's no objection, I presume.
There is, Your Honor, I do have my witnesses present, and this is the second time I'm present. I understand, and Mr. Elman has been very good about email correspondence with me regarding his client. Is there a way that we could continue for a prelim on a new date, but perhaps I'm gonna put my witnesses on standby, and if Mr. Elman confirms his client, because there's also been a misdemeanor offer.
Got it.
For a use.
And maybe, Your Honor, not that I want to push this case in the wrong direction, but maybe it's better to just set it out for PCC and then.
That's not happening.
Okay.
I know.
I
know,
checking.
and I don't know why Elman did, but
Like I said, Your Honor, I need more coffee.
because you're trying to irritate me. That's
My
a fine
apologies.
job you're doing. So here's what I'm going to do. His expected completion date was today.
Correct.
So what I will do is I'll adjourn it to my next date, which is February 3rd.
Yes.
This is a textbook example of judicial control. Calm, decisive, and final. The judge cuts through the back and forth and imposes structure. No overcomplication, no prolonged debate, just a clear ruling, adjourned to a new date. But look at the reasoning. The defendant's expected treatment completion is today. That's critical. The judge isn't just delaying for convenience. He's aligning the court schedule with the defendant's availability. That's efficiency mixed with fairness. At the same time, the judge allows the prosecution's witnesses to remain on call. That's a subtle but important detail. It protects the prosecution from wasting resources while still granting the defense the time they need. This is how experienced judges manage competing interests. No side gets everything, but neither side is unfairly disadvantaged. And notice the tone shift from earlier frustration. The judge regains control of the room. That's authority in action. Not loud, not aggressive, but structured and decisive. Because in a courtroom, control isn't about volume, it's about clarity.
And then I will indicate that the prosecutor's witnesses can be on call.
And Mr. Childers, I'll let you know as soon as I have more information.
All right, so this matter, preliminary examination in person, February 3rd, 2026, 9 a.m. before me. his bond at this time will continue. Thank you.
Thank you, Your Honor. Have a great day.
You do the same.
Judge waited, then waited some more. As attorneys failed to appear and phones rang, patience ran out and the courtroom felt it instantly.
Why was Glick hiding? Why was he hiding?
I was meeting with the victim, Your Honor.
No, not you. Mr. Glick was hiding.
I was talking to my client, Your Honor.
Oh, okay. No, I didn't see you in the room and I said he must be hiding.
I just want a surprise appearance.
No.
We were the first people here, Judge.
Were you? All right. Let's do this.
I didn't drive from Detroit. I'm at a hotel. I
Pardon?
had to go to the jail at night. So I say, you know what?
Stay around. Got it. Court does call the case of the People's State of Michigan versus Stephanie Marie Cruz Mena.
Good morning, Your Honor. Raymond Cook for the people.
Good morning, Your Honor. Jeremy Glick with and on behalf of Ms. Cruz Mena, who's approaching the podium. And Your Honor, if I could just have 2 seconds to tell my client something.
Your name, ma'am?
If you can see your.
Stephanie Cruz, Mena.
All right, we're ready to proceed, Your Honor.
Ready? All right.
This is the date and time set for preliminary examination, and since people are unable to proceed.
This is a critical turning point and one of the most powerful moments in any criminal case. The prosecution is not ready to proceed. That's huge. When the prosecution cannot move forward at a scheduled preliminary exam, it opens the door for dismissal, and the defense immediately jumps on that opportunity. We'd move to dismiss this case. This is strategy in real time. The defense knows the rules. If the state isn't ready, the case can collapse right here. But here's the nuance. Not all dismissals are permanent. Some are without prejudice, meaning the prosecution can refile later. So even when it looks like a win, it may only be temporary. Still, this moment exposes something critical. The burden is always on the prosecution. If they're not prepared, the entire case is at risk. So ask yourself, if you were the defendant standing there, hearing this, would you feel relief or uncertainty knowing the case might come back again?
And Your Honor, given that the people are unable to proceed, we'd move to dismiss this case.
People being unable to proceed this case dismissed on the defense. Hold, sir. I don't know who you are and why you're interrupting my proceedings. And why your phone is on also. Who are you?
Your Honor, can we pass this matter?
Go back. Go back.
Thank you, Your Honor.
Sir, that is not the way that you conduct yourself in here. If you needed to get the prosecutor's attention, there's a way to do that, but interrupting what I'm saying is not going to be good for you. Understood? Thank you. That's it?
Yeah.
Well, now I have attorneys, but are they ready? Ms. Yagi, how are you?
Good morning, Your Honor. I'm doing well. How are you?
You're doing well. Are you guys ready on anything? No?
No, you have to, but hopefully very soon. I just have to talk to Mr. Cook very quickly. But we did talk this morning. We have to talk a second.
That's fine.
Thank you.
Mr. Cook has to talk on that case. So you have nothing else ready?
For right now, I don't know if the defense attorney is ready on Hackner Cantor, but I'm ready on that one.
Who's the defense counsel? Who? Where's he? You wanna know what? Why do I feel like I'm being, ignored? That doesn't work well.
This line cuts deeper than it sounds. The judge isn't joking anymore. This is frustration turning into warning. When a judge feels ignored, it signals a breakdown in courtroom coordination. Attorneys aren't ready. Cases aren't moving. And the authority of the court is being tested. Notice how the judge phrases it, calm but pointed. That doesn't work well. That's not a suggestion. That's a boundary. And then the search begins. Where are the attorneys? Who's responsible? Why isn't anyone ready? This moment highlights a reality most people don't see. Courtrooms are highly dependent on coordination. When even one piece is missing, everything slows down. But the judge doesn't lose control. He keeps pushing forward, trying to move the docket, trying to make something productive happen. Because at the end of the day, the system doesn't stop. It adapts, it adjusts, but it keeps moving.
Where are all the attorneys? I don't, with all due respect to those that are here, but where is Mr. Warren Green?
Would you like me to check next door, Your Honor? He is next door. I just came from next door. I can go get him, Your Honor. Thank you.
This is going well. Should have stayed back. Should have stayed in bed. It showed up around noon and everybody would be ready to go.
You don't look happy.
Why? I'm just looking to do something, but not everybody's cooperating.
I gotta go get the prosecutor. I'll warm something.
Who are you going to go get? Is that something over here?
Yes.
Are you guys ready?
Pretty much. Just a little detail guy. I'll hurry up.
No, you won't. Yeah. It appears, Ms. Yagi, you were unsuccessful.
Your Honor, I was told that Warren Green's case is being called next door. And so it's a very short matter. And so he'll be here within.
Was he on the record?
He was not.
So he's telling me to wait.
Apparently.
Okay, well, court's gonna stand in recess. Court does call the case People versus Connor Rice.
Your Honor, Rob Dowd, Assistant Prosecuting Attorney on behalf of the people.
Ron Brown appearing on behalf of Mr. Rice. Good morning, Your Honor.
Good morning, sir. Your name?
Connor Rice.
Thank you.
Your Honor, today set for a preliminary exam. We're going to, at this time, dismiss counts 1 and 2 and have the case remanded to 14B on count 3 for domestic violence.
This is a classic example of charge negotiation playing out in real time. The prosecution is strategically dropping counts 1 and 2, likely more serious charges, and narrowing the case down to a single remaining count. That's not generosity, that's calculation. When prosecutors dismiss charges, it usually means one of 3 things: insufficient evidence, strategic simplification, or part of a broader agreement. And here, it clearly aligns with the deal structure: reduce exposure, secure a conviction on a manageable charge, and keep the case moving. The defense immediately agrees. No objection. That tells you everything. This outcome benefits both sides. The defendant avoids higher penalties tied to the dismissed counts, while the prosecution still secures a viable case moving forward. But here's the key detail. The case is being remanded for pre-trial. That means it's not over. It's transitioning into the next phase where negotiations, motions, or even trial preparation continue. So while it may look like a resolution, it's actually a repositioning. The battlefield just got smaller, but the fight isn't finished yet.
There's an agreement to do 4A, but I do have one ask regarding bond conditions.
No objection to the dismissal of the felony counts.
And then it's going to be remanded for a pretrial?
Yes, Your Honor.
Or
Pre-trial before Judge Washington.
what it'll do is counts 1 and 2 are dismissed. I'll continue to defendant's not guilty plea as to count 3. A pre-sentence or pretrial will be set
February 2nd at 9 a.m. before Judge Washington.
February. Court does call the case of the People State of Michigan versus Marshawn Smith.
Andrew Childers appearing on behalf of the people.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Smith, is making his way to the podium.
Take your hands out of your pockets.
This moment may seem minor, but it reveals how tightly controlled courtroom behavior is. The judge immediately corrects the defendant's posture, hands in pockets. Why does that matter? Because body language in court is interpreted as attitude. Hands in pockets can be seen as disrespectful, disengaged, or overly casual, and judges don't allow that ambiguity. They expect visible compliance at all times. This isn't about power for the sake of power. It's about maintaining order and ensuring that every participant understands the seriousness of the environment. Then the judge transitions straight into the plea discussion. No delay, no softening. That's intentional. Control is established and proceedings continue. This is how courtroom authority works. It's enforced in small moments, not just big rulings. Because if those small standards slip, the entire structure starts to weaken.
Well, all right. I have your name, sir.
Marshan Smith.
All right. I have before me a plea form that indicates that the defendant will be pleading guilty to the charge of attempted resisting obstruction, 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That is correct, Judge.
That's correct.
All right. Have him sworn.
Raise your hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
Okay, I do.
Lower your hand, state, and then spell your name.
Marshan Duell Smith, Marchandduellsmith.
All right. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. You understand that? He needs your.
Yeah.
Okay. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Washington in the 14B District Court. You understand that?
Yes, I do.
Still wish to plead guilty?
To get this situation over with, Your Honor, like I mean to get this situation over with.
Your Honor, we're perfectly ready to hold an exam if Mr. Smith does not wish to plead guilty. I don't want him pleading guilty simply to get something over with. If he wishes to plead guilty, I'm happy to stand here next to him and do that. But if he doesn't, then I'm happy to hold the exam.
What do you want to do, young man?
Is it possible for at least for the month that I spent in there, I spent over at least 35 days and they're trying to get out on personal bonds. Then, you know what I'm saying, ended up with a personal bond on the 8th, didn't get out on the 8th, just got out yesterday. Like
you're talking about sentencing as opposed to the plea.
I mean, yes, you know, if I can get time credit for the time that I did spend.
I'm not the sentencing, so I can't say I'm going to give you credit for time, sir.
This is one of the most revealing exchanges in the entire case. The defendant is focused on one thing: time served. He's trying to understand if pleading guilty will guarantee credit for the time he's already spent in custody. And the judge immediately draws a hard line. He cannot promise anything about sentencing. That's a critical legal boundary. The judge taking the plea is not the sentencing judge. That responsibility lies with another court. So any expectation of a guaranteed outcome would be misleading and legally improper. The defense attorney steps in to clarify, yes, credit for time served is typical, but it's not guaranteed in the way the defendant is asking. This moment highlights a common tension in criminal cases. Defendants want certainty, but the system often operates on probabilities, not guarantees. And now the pressure builds. Take the plea and accept uncertainty, or proceed to examination and risk something worse. So the real question becomes, are you choosing the known risk or gambling on the unknown outcome?
And I have explained to him that he will get credit for the days he spent against any jail sentence, which I'm not anticipating here, but there's no promise from the prosecutor or, obviously you can't bind Judge Washington, but I've explained to him that he would certainly get credit for the time he's there, but there's no promise of a credit for time served only sentence.
If I do proceed with the proceedings, then
if you what?
Say now, if I do proceed with the proceedings, then I would get what? Like,
you mean with a preliminary exam? If you do that, what are you, I'm trying to figure out what you're asking.
If I do, you know what I'm saying, take the preliminary exam, I mean, what would happen? What will go?
Well, I don't think anybody can say what will happen, but if the people show their case, you'd be bound over to circuit court. And you'd then go to appear on what effectively is what's called a high court misdemeanor or felony charge before Judge Conkey.
This wasn't about the case anymore. It was about respect for the court, and when that line was crossed, the judge made it clear.
And if I may, we made the misdemeanor offer that is available for Mr. Smith today. I cannot promise that that offer will be made again in circuit court.
Listen, young man, again, like I said, I have to make sure that folks understand what they're doing and whatever. So here's what I'm going to do. I know exactly where we left off in this plea. I'm going to step off for 15 minutes. I'm going to let you have another conversation with your attorney and then decide what you want to do. Okay? They've got their witnesses here. Everybody's ready to go. Or you can take the plea or not listen to me and start walking away. All right. Okay, court's going to stand in court recalls case people versus Marshan Smith.
Michael Gandy, Assistant Public Defender for Mr. Smith. State your name, Mr. Smith.
Marshan Smith.
All right, Mr. Smith, we had just begun the taking of the plea. You had been sworn. We're changing this?
No, Your Honor. I believe I've had a chance to speak with Mr. Smith. I have gone over his right to an exam with him. I believe he wants to proceed with the plea, Judge.
All right. So, sir, understanding all of what I previously told you, do you still wish to plead guilty to this charge?
I plead no contest, yes. Is that what I'm supposed to plead or no, I'm not guilty?
Well, what is...
I thought you were going to plead guilty.
Oh, yes. I mean, guilty. I'm sorry. My bad. Yes.
Okay, so you're going to plead guilty to this charge?
Yes.
All right, so to the charge of attempted resisting and obstructing a police officer, how do you plead?
I plead guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind?
Yes.
Yes?
Yes.
You signed an advice of rights form, is that correct?
Yes, I did.
Any question regarding any of those rights?
No.
Okay, I need you to look at paragraph 5. You'll see a copy on the podium. Now, those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No, I am not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Has anybody threatened you or coerced you?
No.
You're doing this voluntarily?
Yes, I am.
Of your own free will?
Yes.
And because you believe that you're guilty of this offense?
Yes.
All right. Get that date. Do I have hang on a quick second. There's a copy for you. What? On the date of December 9th, 2025, at the location of 456 Haynes Street in Ypsilanti Township, Washtenaw County, State of Michigan, did you come into contact with a sheriff deputy?
Yes, I did.
All right. And what happened?
I mean, I could start, you know what I'm saying, from when I got out of jail that day. I did receive tried to call for a simple standby. I guess, you know, something in that didn't happen to where I was able to go to the place. But when I went to my place, you know, I was greeted by the officer. He did tell me to stop, and I didn't stop. I ran.
Okay, so the officer was there. This is a place you weren't supposed to be without a civil standby, right?
I mean, yeah. I did.
Okay. And so you got there, and the deputy you were starting to proceed to it and the deputy told you to stop.
Yes.
And you'd admit that the deputy telling you to stop, that was a lawful command and he was performing his job in doing that, right? And you failed to follow his order or his command.
Yes.
Correct? Okay. All right. Sir, I do have to advise you that from the time that I accept your plea to the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, the court would not be, you would not be able to withdraw your plea, and the court would not be obligated to follow any sentence evaluation or recommendation. You understand that?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor. No, not from the defense, Judge.
And have I complied with the court?
Defense is satisfied, Judge.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this case will be
February 19th at 10 a.m. before Judge Washington.
February 19, 2026, 10 a.m.?
Yes.
10 a.m.
And
before Judge Washington. Yes, sir.
where is Judge Washington's court? Is this the same building?
No, it's not in this building. It's over off of Huron River Drive in Ypsilanti Township.
I'm not.
Okay, what happened is you can call over to the court. I think it's on that sheet, the 14B.
Is that by a Kroger's, if I'm not mistaken?
The Kroger's and
is the post office right there?
Yep.
Okay.
You know where
I know.
Yep.
Yeah.
That's
because we had to go get our mail. We stayed in Arbor One in there. Yeah.
Got it.
Yeah,
okay. Yep. It's that court right down the street.
Okay.
Okay.
Sir.
All right. Thank you, sir.
February 19th at 10 a.m. Okay.
Yes.
I got it on here. Thank you.
Okay. Thank you.
And this is where everything lands. The plea is accepted. Count 1 is dismissed. The defendant is now officially convicted on the reduced charge. What started as uncertainty ends in resolution, but not finality, because sentencing is still ahead. And that's where the real consequences are determined. Notice how the judge carefully confirms everything before accepting the plea. Rights waived, no coercion, full understanding. That's essential. A plea must be airtight. If there's any doubt, it can be challenged later. Then comes scheduling, February 19th. Another courtroom. Another judge. That separation matters. It ensures fairness by keeping the plea process and sentencing independent. But let's step back and look at the full picture. Charges reduced, plea entered, case moves forward. This is how most criminal cases resolve. Not through dramatic trials, but through strategic decisions, negotiations, and calculated risks. And now, the final outcome depends on sentencing. Was this the right move? Did the defendant minimize damage or accept consequences too quickly? That's the question this case leaves behind. If you found this breakdown insightful, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more courtroom analysis and real case breakdowns.